The information discussed in this presentation is current as of the date noted, is for informational purposes only, and does not intend to address the financial objectives, situation, or specific needs of any individual investor. Any information is for illustrative purposes only and is not intended to serve as investment, tax, or legal advice, since the availability, and effectiveness of any strategy is dependent upon your individual facts and circumstances. Results will vary, and no suggestion is made about how any specific solution or strategy will perform in reality.
So our first slide, we start out with why estate planning matters. So creating an estate plan can help ensure your wishes are met upon your passing. It helps leave a plan to follow when you do pass. It can help limit your family disputes, minimize taxes, and prevent a drawn-out estate. So a couple of common myths and misconceptions. The first one is that estate planning is only for the wealthy. So everyone can and really should create an estate plan, no matter your level of wealth. The next one here is estate planning is a one-time task. If you kind of take a look at your life and think about your day-to-day and what it looks like and how it looks pretty similar, but then you back up and maybe think month by month or year over year, your lives are really always changing and can look drastically different over time. And you want your estate plan to reflect this and update as your life kind of changes. The third one here is if you die without a will, everything goes to the state. This is actually called dying intestate. The process differs depending on the state that you live in, and you should really consult an attorney if you or a loved one passes in this situation. But just for a quick example for New York State, if you do pass and say you're married with no children, your spouse would get all your assets. That's kind of a good way to look at things. So the next one up is that you're too young for estate planning. The short answer is that nobody is too young for estate planning. A little bit longer answer is it depends on your situation and what assets you own and kind of your family dynamic. But as a general rule, if you're above the age of 18 and you own assets, you should have an estate plan. Next is having a will avoids probate, and that trusts avoid estate taxes. So having a will does not actually avoid probate. It can help make the process a lot easier and faster and a little less painful because your wishes are laid out in a document. And the short answer for trust avoiding tax, I know Jake will kind of dive into this a little bit later into our presentation, but they do not automatically avoid estate tax. And the last one here is that you don't have enough money to worry about estate tax. This may be true at the federal level. Again, Jake will kind of get into this a little bit with the expiration of the Tax Cuts and Jobs Act coming up. It may or may not change kind of the outlook on that. But some states do have their own estate tax, and those can have much lower thresholds. I know Pennsylvania, for example, has an inheritance tax. So what we'll cover today are the core components of an estate plan, estate tax and asset protection strategies, common challenges associated with estate planning, and the process of creating an estate plan.
So first, we're going to look at what is an estate. So it is pretty much everything you own, your assets and your liabilities at the time of your death. Assets is more than just your accounts and cars and properties. It can include collectibles, your furnishings. It can even include life insurance, because when you pass, that does become an asset for your heirs and whoever is set to get that life insurance upon that time. Yeah. Liabilities, that's just your debt. So any mortgages, any auto loans, any credit card debt, that also plays a factor into your estate. And then in terms of an estate plan, the three main documents are your will, power of attorney, and healthcare proxy. Many people have heard from wills, whether it's from movies or just in talking with one another, but that pretty much says this is where I want my property to go upon passing. Power of attorney is essentially a document electing someone to make financial decisions on your behalf in the event you're not able to. So if you get into an accident, your in the hospital and you can't handle any of your financial affairs, that's kind of what this person will help with. Healthcare proxy is very similar, but on the medical issues and any healthcare decisions that need to be made. Nate's going to touch on all these more, so I don't want to go into too much depth. Living will, just a brief explanation, is what you want to happen in your end of life care, if depending on different situations there, and then also potentially a trust, which there are tons of those that we'll touch on a few of them today, but can certainly help with your estate plan in the right situations. Who needs an estate plan? Nate touched on this a little bit in the last slide, but everyone above the age of 18, everyone especially above college age with assets. It doesn't really matter, I'm too young, I don't need it, but especially the power of attorney and healthcare proxy can be big factors to play if something were to happen to you, regardless of your age, and then also regardless of estate size or complexity of assets. Just having the estate plan makes it a lot easier for your loved ones. The last thing you want them to be doing when you're hurt or passed is dealing with problems and arguments with other family members, and it just makes it a lot easier with the courts and attorneys and quicker and cheaper.
On to the will. What is it and what does it do? So a will is a document that outlines how you want your assets distributed after you pass. So what they do cover are things like asset distribution, guardianship if you have young children, funeral arrangements upon your passing, as well as who your executor and contingent executors will be. And an executor is just the person in charge of administering your will. They do not cover, however, assets owned jointly, assets owned within a trust, and assets with a beneficiary designation. And we have touched already kind of on who needs a will, and really the short answer to that is everybody. And the power of attorney. So a power of attorney is a legal document that allows somebody to act on your behalf in managing financial affairs, making legal decisions, or handling specific tasks. These tasks can really, there's no real limit to them as long as you put it in the power of attorney. So two common terms you'll see on the power of attorney are the principal and the agent. The principal is the person granting the power of attorney, and the agent is the person authorized to act on the behalf of the principal. So another important part of the POA is the scope of authority. And so the scope can be limited to specific tasks, like I mentioned before, or it can provide a broader authority. And it's important to note durable versus non-durable powers of attorney. A durable power of attorney would remain in effect if the principal becomes incapacitated, and a non-durable power of attorney would terminate if the principal became incapacitated. In a healthcare proxy, so it can be covered under the power of attorney if the terms are broad, like I mentioned, or you can have a separate document if the terms are more specific in that power of attorney. So it really kind of depends on how that power of attorney is written, whether or not you need the healthcare proxy.
And with both of those documents, just one thing to add is they only are, obviously this one, but more so for the POA, is they're only valid while you're living. When you pass, you can make financial decisions for them, and then obviously none of the healthcare decisions, because that wouldn't matter as much at the time.
Yep. Then on to living wills, as Jake somewhat touched on earlier. So they outline your preferences for medical treatments and end-of-life care. It's important really to think about the situations that you may be in, however unpleasant it may be, and that you name a trusted agent to kind of handle these situations for you. And it's important to have your wishes laid out in advance so that whatever does happen, you're not put in a position you don't want to be and you have a plan in place.
So now we're going to get into the tax side of things. So there's a federal estate tax, and then there's also state estate tax, and also some inheritance tax based on the state you're in. So looking at the map, you can see there's not as many with either of them, but there are still a few. So there's 6 with inheritance tax, and there are 12 with estate tax plus DC. There's one that has both of them, and that's Maryland. Um, so it just depends on state by state. But one thing to really keep in mind is the difference between the two. Estate tax is paid by the decedent or the person passed, basically by the assets they had, so by their estate. Inheritance tax, on the other hand, is paid by the person who receives the inheritance. Usually it's not a big deal because you'll just pay with it out of whatever you inherit. But with properties or something, for that example, that can be hard to really pay and get that cash flow to pay the tax due. With these as well, it's something to keep in mind is that there can be differing tax levels based on your relationship to the decedent or the person who passed. Generally, with a spouse, most of these are tax-free. There's no implications there. But if you're a child, there could be a tax rate. Maybe if you're a sibling, that can even have a higher tax rate than what your child might. And then if there's no really direct relationship there, it could have a different one as well. One last note I want to say about this for the inheritance tax is it applies to where the person who passed lived. So if I live in Florida and I inherit something from somebody in PA, there could still be inheritance tax payable because PA has it, even though Florida doesn't. And it can also get tricky where if we are both not in state with an inheritance tax, but there is a property that I inherit in a state, so in the state of PA, and that can also create some implications there as well. So now we're going to get into the federal estate tax. This is a little bit easier because it's one rule above all. So a couple of years ago, you might have heard of the Tax Cut and Jobs Act. This really increased the estate exemption per person, and it's been going up with inflation over the past couple of years, but currently this year it is about 14 million per person. So again, that kind of causes a lot of people not to have to worry about federal estate tax. But one thing to keep in mind that it currently is set to sunset at the end of this year. Depending on, they could renew it, they could let it expire. Either way, if it does expire, it could revert back to about $6 or $7 million per person. It's basically the level it was when the Tax Cut and Jobs Act was implemented, but inflated annually over the years. It hasn't been there. So that's something to definitely keep in mind this year and next, depending on what happens there. If you fall into that, 12 to $14 million of net worth range. So now we're going to get into some gifting strategies and annual exclusions. So first and foremost, each year there's an annual gifting exclusion that anyone can use for any single person. So in 2025, it's $19,000. It increases for inflation year over year just slightly, so it's something to keep in mind. But so for example, for this annual exclusion, I could give every single person on this individual person on this in this presentation $19,000, but I can't give one person more. Now let's say I'm married and I have a spouse. Me and my spouse combined can give each person on this call $38,000 a year. No implications, no tax return requirements, nothing, as long as it's under that $19,000 a year. Next, we're going to look at bunching your gifts in 1 year or a donor advised fund. So this goes more into the itemized deductions. Another thing the Tax Cut and Jobs Act did a few years ago was really raise that standard deduction. So not as many people use it as much, but an itemized deduction, if you use them, can be beneficial in any way to get that higher, helps your tax return. So one strategy we like to mention is bunching your gifts in 1 year or contributing to a donor advised fund. Pretty much if you're able to, and you give $10,000 a year to a charity, 1 year you should try to give maybe $30,000 instead, because then that all of that is able to be itemized in 1 year and can lower your tax return. Donor advised fund is pretty much the same thing. You just contribute to that donor advised fund, and that whole amount is able to be itemized in that 1 year. The next strategy we're going to look at is gifting assets that will appreciate in value into a lower tax bracket. So say I'm at a very high tax bracket, I've got very high income, and it was 5 years ago, and I had the brilliance to know NVIDIA is going to just explode over the next couple of years. I could give those to maybe a child of mine or someone else in a very low tax bracket with very minimal income, and they will hopefully pay less in capital gains rate on that if it does in fact appreciate and they decide to sell it. Kind of on the same idea. So say I didn't know NVIDIA was going to explode and I kept those assets and they've appreciated a ton, and I'm going to be paying the highest capital gains tax rate on those. A great way to go about that is to gift it to a charity. So not only do I get the tax benefit of the fair market value of those, the charity gets the full value and they can sell it with no tax rates because they're a tax exempt organization. One thing to keep in mind with these are that they have to be long-term appreciated stocks, or assets. So that's held for over a year. Another big consideration, especially with college getting so expensive and medical expenses being up there as well, is that if you gift directly to a college, a university, or even a hospital, it has to go directly to them. That doesn't count towards your annual exclusion of $19,000. It doesn't count for anything really. So it's a free gift. It helps people pay for their kids' college educations and any big medical expenses they might have. So it's a great way to get by those rules and not using your annual exclusion or your overall exclusion. And then trust, this is another good strategy, and there's a couple different options here, but I won't get too much into it because there's another slide that dives a lot deeper into that. So protecting assets for heirs. So one thing that is very important for people with special needs children or family members is planning for them if something were to happen. A great strategy for this is special needs trust. A key component of this is that it keeps the assets so that they are not accountable asset for the beneficiary. That's the reason behind that is because people with special needs or people disabled can generally receive government benefits that have very strict asset and income limits. So this is kind of a way to make sure they're taken care of without lowering their eligibility for any of those benefits. And then also shielding assets from creditors and lawsuits. Trusts can come into play here. For example, let's say I have a trust, I pass, so one of my kids now gets this trust. While the assets are in there, they're somewhat protected from divorces, lawsuits, and creditors. Now say they withdraw the whole amount from the trust, close it down, it becomes their personal property, which now can be able to be sued in a lawsuit or taken as divorce. It's something to keep in mind when you're taking that money out of the trust, what the potential implications are there. So now we're going to get into some of the trusts in charitable giving. So there's two main types of charitable giving trusts. One is a charitable remainder trust and the other is a charitable lead trust. They're essentially just inverses of each other. So the remainder, essentially you or the beneficiary you elect get the income from that trust for life. Then when you pass, the large gift goes directly to the charity. With that, you get the immediate tax benefit of the present value of that trust because it's irrevocable, so it can't be changed, and no matter what, that gift when you pass is going to go to the charity. With the charitable lead trust, it's essentially the opposite. The income goes to the charity depending on the trust terms, or maybe it's when you pass, but then when that happens or that time comes, whatever is left can be given to the beneficiaries. And with this, you get a tax benefit for that income paid out to the charity rather than the gift at the end. Donor advised funds, I touched on these a little bit. So these are another good option. Those two trusts I mentioned before are good for large gifts and very complex, more expensive gifts because they are expensive to have attorneys draft those up. A donor advised fund is a simpler and cheaper way to establish some contributions and charitable giving. So pretty much you set up an account, you can do a lump sum, you can which is generally better because of what we talked about earlier with the itemized deductions. But you can say, I give $100,000 to this donor advised fund. I get that on my itemized deductions. And from there, you can generally direct where the funds go, whether it's one charity one year or one charity the next year, but it doesn't all have to be spent. It can kind of distribute that over time rather than just me writing a check to the charity where they get all the money at once.
So some common challenges that come up in estate planning. The first two, family dynamics and planning for blended families, really kind of go hand in hand when it comes to some tips for that. So ways to kind of combat it and get ahead of it are to be proactive, communicate openly, to use clear and detailed documents. It can really help move the needle there. Utilizing trusts are always a good idea in these situations. And if necessary, you can move to mediation. So next, for outdated plans, as I mentioned before, estate plans aren't just one and done. You really want to get ahead of it and review them regularly, whether that's 5 years, 10 years, or whatever works for you, or review them after trigger events. And trigger events are really just life events that and they can include things like marriage, divorce, a new child, a change in financial standing, a death in the family. After any of these kind of come up, assets could be going to the wrong person, the wrong beneficiary, your trustee or agent could be out of your life. You never really know, so it's good to review things and make sure that everything's in order. And then with digital assets, this day and age, a lot of people have online accounts, whether it's social media or online bank accounts or things of that nature. So what we recommend to clients is really just to have a plan for those digital assets and accounts in your estate. And some things that we advise for them to do is to keep a list of digital property and accounts and usernames and passwords in a safe place. And in your will, you can actually name someone to close those online accounts and to handle the dispersal of that digital property upon your passing.
One thing I just want to add there with the outdated plans is that there might not even be a triggering event. So say, maybe I'm 30 or 40 and I want my parents to be the executor, the power of attorney, and guardian for my children. Even if they don't pass, as they get older, they may not be fit to do those positions. I mean, they may not want to have children running around, and maybe that's when I can change it to a friend or something like that. Or even say, I was really close with somebody when I was 30. Now I'm 50. I haven't talked to them in 20 years. I don't know if I want them being guardian of my children. It's just something to keep in mind as you age and maybe relationships change over time.
Yep, that's a great point, Jake.
Now, so kind of to end it all up, the process of creating an estate plan. So it's very important to inventory your asset. And like we talked, make sure you are aware of which ones are and are not dictated by the will. If your will says everything goes to my child, but my beneficiary designated IRA says it goes to Nate, it's going to go to Nate. The will does not overpower those beneficiary designations. So just be aware of what you have, what's needed for the estate, and what is dictated, as in where does it go. You want to identify your goals and priorities. Where do you want your money to go? If you want it to go somewhere, are they okay receiving it all at once? Should it maybe be put in a trust so they can't just buy a new car with all the money you give them or anything like that? And then last but not least, I'm sure some of you are wondering why a couple of financial advisors are talking to you about an estate plan. Well, while attorneys will draft up the documents, it's very important to have a team for your estate plan and just your financial life overall. An attorney can help obviously draft the documents and make recommendations there, but it's important to make sure all of your accounts are and all of your financial life is kind of pulling the same way. For example, if you have your account designated as the different beneficiary than where you really want it to go, it's important to make those changes so that they match your estate plan. It's important to be aware of estate taxes, inheritance taxes, gift taxes, where that's where your financial advisor or tax professional comes into play. So it's very important to have those parties in your lives and making sure that everything is all squared away, because the last thing you want to do is think everything's squared away and everything's all set and then either get hit with a big tax bill or the plan isn't what I want it to be or anything like that. So it's always important to make sure those are all always good rather than just good at one point in your life.